the Chief Justice of the Republic of the Philippines, the Honorable Maria Lourdes P.A. Sereno. And members of the media during the first anniversary of her appointment in August 2013. It is by now the third time that we are conducting this press conference, and we are happy to be joined by select members of the media who will form a panel who will interview and ask questions of the Chief Justice. We're being carried live on the major net television and radio networks. The Supreme Court Public Information Office is also live streaming this afternoon's proceedings. You may follow us through the PIO's Twitter account at SCPH_PIO, hashtag CJ Meets Press, and hashtag AskCJ We will start this afternoon's press conference with an introductory message from the Chief Justice. Ladies and gentlemen, the Chief Justice of the Republic of the Philippines, the Honorable Maria Lourdes P.A. Sereno.
Good afternoon, everyone. Allow me to use this opportunity to briefly report you on the judiciary's year. From the standpoint of judicial reforms, the adage that you cannot argue with success has been our common experience this year. The judiciary has been able to succeed in putting several important reforms in place within a short period of time. And may I share with you some of our success stories and reform projects, and these are the following. If you remember, the Judicial project, our one-time case decongestion program, which we launched in Quezon City in 2013, has already resulted in a 30% reduction of caseload in the pilot area. It is now being rolled out in Angeles City, Makati City, Pasig, Davao, and Cebu. The program seeks to reduce overall case dockets nationwide by 20% up to 2016. We are also going to hire for the next year, 635 specially trained court decongestion officers so that we can assist our most burdened courts, and which courts we have identified carry 54% of the total caseload in our courts nationwide. Their deployment aims to reduce by a minimum of 5%, and remember in Quezon City, it was to the extent of the 30% reduction, the caseload of the target courts within 12 months from start of deployment. The continuous trial system. Recently, we launched it, and it is a system whereby the courts conduct continuous trial for the speedy resolution of cases, using the existing rules of procedure but emphasizing a more determined effort to avoid delay by judges and litigants. The system prohibits motions for postponement and sets fixed pre-trial and trial dates. It is currently rolled out in 52 pilot RTCs and 6 pilot MTCs in Manila, Quezon City, and Makati. You know, the popular perception among you, and you have carried also this line, is takes an average of about 5 to 7 years for any trial to end. Now, with the continuous trial, we hope to reduce these 5 to 7 years to as short as 6 months. For very simple cases, it can even be finished within 2 weeks. Of course, with respect to very complicated cases such as the Maguindanao massacre case, we cannot apply the same timeline. Now, we also have an assisting courts system whereby we address the disproportionate allocation of courts in various parts of the country with assisting courts, whereby less congested courts are tasked to help overburdened courts deal with the heavier caseloads. We are currently implementing these in the following areas. 20 METCs in Manila, assisting 7 METCs in Makati, and 20 in Quezon City. 12 RTCs in Cebu City, assisting 3 RTCs in Mandaue and 3 in Lapu-Lapu. 1 MCTC in Compostela, Cordova, assisting 1 MTCC in Lapu-Lapu. We also have the judicial affidavit rule, which we implemented in 2013, and where judicial affidavits are now being utilized in lieu of direct examination. And you know, it has been effective in reducing the time used for presenting the testimonies of witnesses and ultimately help address court congestion and case delay. It can cut the trial time to as much as half. Pilot of Rules 22 and 24 in the Rules on Civil Procedure, we are enhancing preliminary conference and in the pilot courts and using innovative techniques such as certain discovery measures, mandatory disclosure of evidence, and a detailed face-to-face examination of witnesses. All 54 pilot courts have already undergone extensive training and have started implementing it. The Quezon City Practice Guidelines in Litigation, whereby we authorized the use of certain practice guidelines that are innovative to speed up the length of trial. It features limitations to the length of pleadings, kinds of motions and number of postponements, strict timeframes, and mandated judicial affidavits. The guidelines also authorize the use of private couriers, and it has produced dramatic results and being currently assessed for potential rollout to other court stations. I hope I am not too fast this time because, Teddy has been giving me instructions to speed up things because he's very much conscious of media time. But you can tell me to go slower if you want. Slower. So, Teddy, see? I was telling him this is not my natural cadence, but he was telling me I have to try. Now, after reading 2 pages of this, I'm proven right. Okay, so I'll switch back to my normal. All right. Now, one very dramatic intervention we have created is the e-court, which is an automated case management system. And it is expected not only to increase efficiency in the processing and monitoring of cases, but it also very importantly enhances transparency and assures record integrity. Because there will be an electronic footprint from beginning to disposition of the case. There can be monitors at several levels. From the electronic raffle, so human mediation is no longer allowed, all the way up to case disposition, and even the time it is taking for the case to be processed, both the court administrator and the executive judge will be monitoring it, including the judge himself. And in future, it can even be monitored from my office. So you can be assured, therefore, that the constitutional concept of accountability will be really heightened dramatically with the nationwide rollout. Now, it was piloted in Quezon City. It has achieved much success, and we are already implementing it in some of the biggest dockets, the courts with the biggest dockets. And may I give you the state so that you will have the correct expectation. As of August 2015, there are already 82 operational e-courts covering all the courts in Quezon City, Angeles City, Lapu-Lapu City, and take special note, Tacloban City. By the way, Congressman Tanyada is here, so I was so surprised to see you among the panel members. So thank you for being here with us. In the second half of 2015, which is already starting now, e-courts will be rolled out to 85 more courts in Davao City, Cebu City, and Makati City, meaning the additional courts that have not already had the benefit of a rollout, bringing to 167 the e-courts by the end of 2015. And e-courts will be further rolled out next year to 120 more courts in Manila, Pasig City, and Mandaluyong City. And by the end of 2016, it will be in 287 trial courts, and we will already see that it will be handling about 30% of the total caseload of the Philippine court system. Now, for 2017 onwards, we are hoping to get the support of the public in allowing us to get more money from Congress so that we can really have a nationwide rollout of the e-court system. Because right now, the money that we are deploying for the e-court system in large part is funded from development partners. For automated hearings, as an offshoot of the use of the e-court system, one feature, the automated hearing system, has transformed the entire courtroom into an automated trial forum. This means that during trial, every activity is captured electronically right there and then, including orders issued by the judge, minutes of the hearing conducted, the judge's note and the testimony taken, the marking of evidence, the issuance of writs, and court processes. This is done by linking the computers of the judge, the stenographer, the interpreters, allowing all individuals to view and edit real-time the documents that are being prepared. As of date, 100 courts in Quezon City, Angeles City, Tacloban, Davao, and Lapu-Lapu have been provided the equipment and training to conduct automated hearings. Most of these courts are now implementing the same. Automated hearing is targeted to be implemented in all NCR courts by 2016. The EISP, or the Enterprise Information Systems Plan, it is the Judiciary's 5-year ICT Master Plan. It identifies more than 20 software application systems to speed up the adjudication of cases, increase personnel productivity, and improve court and case management. In 2014, we updated it to address the gaps, and we now include also infrastructure components needed to implement the plan on a nationwide basis. It includes an enterprise-grade data center, nationwide connectivity, and network security. Now, this data center will be backed up by regional data centers so that whatever disaster hits one part of the country, we will still be able to find the data somewhere else. As of the date, today, the following have already been taken to implement the program. Contracts for the main data center upgrade and the data center disaster recovery site, that is where the disaster site will be, in Angeles City, and the virtual integrated systems infrastructure, the servers and the other hardware necessary to put in the data centers have already been awarded, and it constitutes 30% of the budget. The bidding for phase 1 of the nationwide connectivity project is ongoing. For the first time, we really hope to provide genuine, reliable connectivity to our courts. So there is no reason for any delay on any court process and any court reporting. Phase 1 covers the targeted cities in 2014 to 2016 of the following: Quezon City, Angeles, Lapu-Lapu, Tacloban, Davao, Cebu, Manila, Pasig, Mandaluyong, and all the other courts in the NCR, Regions 4A, and Region 7. These 3 regions have the highest caseloads in the country. Internet access will increase the court and the judges' access to legal materials and increase their efficiency. Scheduled for bidding in the 3rd quarter of 2015 are the Regional Data Center for the Courts in the Visayas, Document Records and Archive Management System, Hearing Management System Pilot in the Sandigan Bayan, and digitization of court records. Now, with respect to infrastructure, you have already heard me announce that the court is planning to move in several years' time to the Fort Bonifacio development area. And in May of 2014, the BCDA and the court executed a memorandum of understanding for the option to purchase a 2-hectare lot at the price of 1.29 billion. This will be the site of the new Supreme Court complex. Repair and rehabilitation of halls of justice. In 2012, the court allotted money for the repair and rehabilitation of various halls of justice nationwide. As of August 2015, the repair and rehabilitation of 23 halls of justice were completed. Repair works are ongoing in 10 HOJs, halls of justice. It is set we are going to award the contracts for the repair of 19 more HOJs. And we are now bidding the rehabilitation of 23 more HOJs. 12 projects for the construction of new halls of justice are the priorities in 2016, including the design phase for the halls of justice of Cebu City and Cagayan de Oro City, and the construction of 10 smaller HOJs. In January of 2015, a fire destroyed the Cagayan de Oro HOJ. The 23-year-old Palace of Justice in Cebu was also seriously damaged earlier. So the following are our priorities for construction in 2016. Cebu City, DAED, and PM. Lawag, Ilocos Norte. Lalio, Cagayan. Kasibu, Nueva Vizcaya. Tangkawayan, Quezon. Leyte, Leyte. Kapatagan, Lanao del Norte. Jimenez, Misamis Oriental. Salay, Misamis Oriental. Kumalarang, Zamboanga del Sur. Island Garden of City of Samal, Davao del Norte. As an aside, may I tell you why I am making this announcement via a nationwide address? It has really been only now that the executive department has seen fit to entrust us with the money to build our own halls of justice. For all this time, I think some of you know, the LGUs and of justice have undertaken the construction of our courthouses. It seems unseemly for us that we, an independent branch of government, should be dependent for our infrastructure needs on when an LGU or the DOJ sees fit to construct a house for our operations. This is no longer true nowadays. We now have some money given to us to start this building program, which we have matched up with the savings from our own regular appropriations and the appropriations, savings also that we have accumulated through the Judiciary Development Fund. The Supreme Court's building is going to be supported by a request for GAA funding, not from the JDF. Now, for the Manila City Hall of Justice, and some of you reporters, I think, Ray, you knew even then that we had several groundbreaking already for the Manila Hall of Justice. This time, in 2014, we were finally, and we did this by setting aside money from our savings. The bidding for the detailed architectural and engineering design is nearly complete. The actual design is expected to be finished in the third quarter of 2016. Construction will start in 2017, and we expect it to be completed in 2019. Now, in the area of administration of justice, the case that many of you have been regularly monitoring, the Maguindanao massacre cases. As of August 26, 2015, the court, which is yesterday, the court has already heard a total of 175 witnesses, 93 for the prosecution, 24 for the defense, and testimonies from the families of the 58 victims of mass killings. The trial court has resolved all outstanding formal offers of evidence against the bail applications of the accused. It has thus resolved all major bail applications, with only those of the main accused, Andal Unsay Ampatuan Jr. and Zaldi Ampatuan, remaining. Accordingly, the proceedings have already reached the hearing of the evidence in chief. It has gone beyond the bail hearings now. As of this writing, only the accused, Unsay Ampatuan Jr., is left in presenting his evidence in the bail hearings. But the court has already ordered him to close his presentation of evidence no later than October 2015. These cases have already progressed considerably. In fact, the prosecution has already rested its main case for 9 accused last June 3, 2015, and for 45 of the accused last 10 August 2015. So the prosecution has rested its case for 48 of the accused. With the continuous flow of the trial, it is hoped that both prosecution and defense will fully rest their cases this year, and by then these will already be submitted for the decision of this court. I think that in the context of these, being one of the most complex cases in the world, the pace of work by our judge has been outstanding. Consider the Oscar Pistorius case, which took 1 year with devoted time and effort by all parties, but where there was only one victim and one suspect. Corruption. The court has shown its continuing resolve to deal with misconduct in the judiciary's ranks, whether arising from corruption or from inefficiency, if warranted by the evidence presented. Of 340 cases filed against justices of the third-level courts and judges of the first and second-level courts, from January 2014 to April 2015, the court resolved 343, including some carryovers, dismissing 278 cases and meting out appropriate penalties on the remaining ones. 1 Sandigan Bayan justice and 1 RTC judge was dismissed. 15 were admonished, 29 were fined, 7 were suspended, and 7 more were reprimanded. The Judiciary Development Fund. In 2015, the Judiciary Development Fund Committee was organized and tasked with making current the guidelines issued by the court in relation to PD 1949 or the JDF to ensure consistency in policies and efficiency in procedures. This committee, which is made up of representatives from all levels of courts and all the tertiary courts, is currently reviewing all existing issuances on the JDF. It has evaluated all audit observations made by the COA and is submitting recommendations to the Chief Justice regarding the administration and allocation of the JDF to ensure constant compliance with constitutional mandates, PD 1949, and other pertinent laws, rules, and regulations while ensuring administrative efficiency. As you know, all financial reports on the JDF have been posted online. COA has continuously been fully auditing the JDF, and the 80% share of the employees for their monthly COA have been regularly, religiously, and promptly released. For family courts, as part of the first phase of the implementation of the Family Courts Act of 8369, circa 1997, Congressman Tañada, a 1997 law passed is only right now being implemented. The court for this year approved the organization of 48 family courts in the NCR, and I hope this is a special appeal to Congress. Regions 3 and 4. These courts have been identified as having the highest number of pending child and family cases, which together account for 52.46% of all child and family cases in the country. The organization of these courts is being done only now, because it is only for the first time that money is being allotted to the organization, to the funding of these courts. Before, what we used to do is to just give additional designations or assignments to our regular courts. But now, we are going to have fully funded courts with the necessary technical complement, such as the correct social worker complement and child psychologist complement, as well as the correct facilities so that the mandate of the law for the full protection of children's and women's rights, as well as the issues of family disputes, will be properly resolved. Now, with respect to the Judicial and Bar Council, which is an independent constitutional body under the administrative supervision of the court, but which I head, due to systems improvements, the JBC was able to process, note, 7,100 applications for only 109 positions, signifying its commitment to improving its administrative efficiency. You will note, please, that the high number of applicants indicate a greater competitiveness for judicial positions. This, compared to the 4,403 applications processed by the JBC for 247 positions in 2013. When I started, actually, the processing rate of JBC applications was only in the high 1,000. As of date, there is only a 16.54 16.54% vacancy rate for organized courts, which is quite a major improvement considering a 15% vacancy rate in any organization is not really a dismal vacancy rate. It has developed a survey system to obtain feedback and information on the qualifications and reputation of candidates for positions in the judiciary, particularly positions in the tertiary courts. It also has introduced an essay writing system, a very intensive interview system, and it is right now in consultation with international experts to even make the survey form even more inquisitive than it already is. You will be surprised in the next few months. You will find out that our survey questions will be asking even to questions of conflict of interest relating to the applicants' family members. The results of the survey serve as a guide in the evaluation of the candidates, and these have been made to ensure that only the best candidates are included in the shortlist. And if you notice, the lists are indeed getting shorter and shorter, indicating the kind of time and effort expended before the JBC is able to generate a short list of nominees to be submitted to the President. May I just mention the EJAW and the Expanded Justice on Wheels program, which carries the public face of the judiciary, provides a venue to effect the release of detainees for civil cases to be mediated, to attend to their medical, dental, and legal needs, and especially addressing the needs of detention prisoners. The Judgment Day, a component of the EJAW, and sometimes we need not have the EJAW to have a Judgment Day, requires the judges to render decisions immediately in a selected number of cases. As of from the period of February to November 2014 alone, 250 inmates were released. And this is out of more than 1,000 cases heard in the mobile courts that we had. With respect to interagency coordination, if you will recall, the JSCC, or the Justice Sector Coordinating Council, had been organized to serve as a forum for dialogues on issues of common interest, and it is a mechanism to have coordinative efforts between the Supreme Court, representing the entire judiciary, the DOJ, and the DILG, while at all times being careful to respect the independence of these offices. We launched in November 2014, and some of you were there, the Justice Zone, and it is the flagship project of the Council. And may I point out the key reform projects in the Justice Zone. The first is, we had announced the results of this, is the e-subpoena, whereby the simple emailing system and the automatic meting out of administrative penalties if policemen are found to be unjustifiably evading a court process to act as police witness when they had been indicated as the witness. Because of these twin mechanisms, which are very, very simple, we saw a 97% compliance rate by policemen attending trial in Quezon City. Whereas before, policemen absenteeism in crucial hearings has been accountable for many of the delays that we had encountered in criminal cases. Building on this success, the court has just approved its rollout in Angeles City this year. We are still identifying more sites where the convergence of the enthusiasm of the judges and the enthusiasm of the police forces are there, so that we can have e-subpoena in more and more jurisdictions. And we have also a sector-wide capacity building program now. You know, it used to be that these pillars of the criminal justice system moved in silos. Now we have trainings provided to all justice sector actors, such as forensic training of judges, prosecutors, and public attorneys, training on the preparation and use of judicial affidavits and templates for public attorneys, PNP, NBI, and PDEA. The feedback to me has been that the judges have found these training programs very, very important, and it has greatly improved their ability to appreciate the kind of evidence that have been presented before them. Synchronized calendars. One reason why we have delays is that the judge and the prosecutor will be absent at different dates, or even the PA will be absent at different dates, making the trial of compelling the court calendar to be further delayed for particular cases. What we do now is require all of these three major actors in the criminal justice system to sit down and come up with a synchronized calendar for the entire year. So everyone can plot his calendar and there will be less, very, very minimal delay of any trial. We also have the Evidence Management System project, which is currently being developed by a technical working group comprised of members for the judiciary, PNP, NBI, and others to improve evidence handling and marking to ensure that the chain of custody is not lost and that we will always be able to ensure the integrity of the evidence that is being considered part of the judicial record. Now, upon strong advice by Attorney Te, I have to close now. But we will have, I really was rushing my delivery, and I think it also notes the pace in which I have been trying to move forward. And it has indeed been a very busy and fruitful year. We do not, however, rest on this because we have just barely scratched the surface. There are so many indicators of injustice still in this country, so many prisoners that still have to see genuine justice being delivered. At the same time, you have families of victims waiting for the time when they can actually call that there has been a closure for a matter that has been litigated and has been pending in court for years. I know, of course, of the famous trials that have ended after 18 years. We have the ozone disco issue. I can tell you that these are not the last that you will hear about. That is been but what I can tell you is that the reform program right now is being systematically undertaken. It has to be done by a scientific study of the evidence on record. It has to be done by deploying the necessary amount of people and software and hardware and the financial assistance required to make all of these move. That is why I have made a very impassioned plea to the executive department and also to the legislature that this is a matter that is important for our nation's development. It is not just roads and highways or the social alleviation programs that are important. Justice is important, and it must be funded correctly so that our people can really have the satisfaction of saying that justice is finally at hand. Because while I can dish out to you every year numbers and statistics, and I think that many of them will continue to show improvements while we can continue unearthing major problems. And there are so many. I think that when I hear stories from judges, lawyers, and litigants, I need to share these with you as well. Because these stories show how these processes, these systems improvements, are actually affecting lives of people and families. Some stories are like lighthearted, like, some lawyers have taken the habit of taking selfies of themselves with the instant orders they finally get from an automated hearing. Because before they used to hear the judge say, after hearing the motions being argued in open court, saying, "All right, this is now submitted for resolution." He will bang the gavel and the session is adjourned. and the judge will hear other cases. Now, this pending matter will lie there, waiting for the time when the judge will finally be able to go back to his notes, and the judge will ask his staff, or he himself will draft an order responding to that particular motion. And then he will give this to his stenographer, and the stenographer will consult the clerk of court, and they will type up the proper form. And it will be given back to the judge for the judge to edit. And after the edited version, it goes back to the staff, and the staff finally gives it back to the judge until he signs the order. After the order is received, then it is given to the process server for mailing. The process server goes to the post office of the city hall, and by using the franking privilege, that order goes through the snail mail system, and it will take 2 months for that mail to be received. And the judge, when the case is next calendared for hearing, will await the certification that, in fact, there is a return of the registered mail stub that says that it has actually been received. Otherwise, there has not been a proper service of the process, and that is a violation of due process. If it has not returned from the post office, then the judge will be forced to reset the hearing for another month or 2. That alone, just imagine that entire process can take months. And if you have a judge who has 1,900, 500 cases, you can just imagine why we have a major problem in our system. The automated hearing system, on the other hand, trains the judge to be comfortable with the most commonly used forms and orders. So he has already a menu in his system. And before the hearing date, he goes over the records, and the researcher, clerk of court, and stenographer can also assist the judge to already choose what is the most appropriate order to prepare. The hearing is conducted, and in that hearing, the judge, because it's not going to be a very complicated order, immediately makes his ruling. In open courts, he dictates it. The stenographer is inputting as the judge is pronouncing it, or the judge himself can input the same in his laptop computer, which is on his desk. There is a back and forth, and it just takes minutes until the judge is satisfied and the judge gives the order to print. The printer is just there, a few meters from where he sits, and once printed and delivered to the judge, he immediately signs and asks the process server, who is right there, to please make the parties receive it. You know, it is as dramatic as saying that justice can indeed be real time. Just imagine the shock of lawyers when for the first time, immediately after a hearing, they have an order in their hands that they can show their clients, and they can immediately collect their appearance fee. Try to think of the professional validation that accompanies that experience. That is why it is not surprising that they take selfies of the order that they just received. It is a phenomenon. So, yes, monumental. So we do away with the snail mail system. We do away with the second guessing of what the order will finally look like. And because it's finally out of the desk of the judge and the stenographer and the clerk of court, the judge now has the time to go over the records for the decisions that the judge is formulating. Now, it is so dramatic that it went beyond the selfies. And in the first ever automated hearing conducted in a regional trial court in Davao City, the accused was there on promulgation day, the family was there, and after the order was read, and it was just, it so shocked I don't know whether it was promulgation day or it was just a simple dismissal on another reason. The experience so shocked the family that on the same time, that within minutes after the judge pronounced the order for release was given. The surprise was so deep that not only not only was the accused crying openly in court, his family was crying too, but the lawyers and the court employees were crying as well. to see that it can be done. You can actually give justice in as concrete a manner as this. In other words, there was actually no reason for the inefficiency in the first place. The problem is that the inefficiency has not been fully addressed. And methods, processes, and systems have not been put in place to address those. So, I believe that this is the kind of justice that our people deserve. And that is why I am appealing to all my kababayan. The fight for justice is a very long one, and it can be very detailed. It can go down to nitty-gritty, because high ideals and motherhood slogans are not enough to bring justice to our people. We have to move to ensure that everything is in sync so that the law is applied evenly to all in as fast, expeditious, and with as reasonable a process as we can muster. So I thank you. I have considered many of you as my friends because you are in the very important public service of reporting to our kababayans what is really happening in the justice sector. So, on behalf of my colleagues in the Supreme Court, I thank you, and I am now ready to take your questions.
Thank you very much, Chief Justice. CJ, may I now be allowed to introduce the members of the media panel who will be asking the questions this afternoon. I will introduce them in the order that they will be asking questions, which was determined by lottery earlier today. The first is Mr. Ed Lingao for TV5, a news veteran, having served in front of and behind the camera, and also currently now the news manager of TV5. No? Sorry. Okay, sorry. That is in your bio. Sorry. Ms. Ina Reformina will ask the second question for ABS-CBN, the Justice Beat reporter for ABS-CBN. She's a member of the Justice Reporters Organization, or JUROR. Third to ask is Ms. Donna Cueto Ibanez for Net25. She was a reporter for Philippine Daily Inquirer for many years and a former JUCRA member. She is currently a member of the Executive Committee of the Eagle Broadcasting Corporation, the mother organization of Net25. The fourth is Ms. Tara Quismundo for the Philippine Daily Inquirer, the reporter for the Philippine Daily Inquirer assigned to the Justice Beat. She's a member of the Justice and Court Reporters Association, or JUCRA. The fifth is a news veteran who has been covering the Justice Beat and has been writing for the Manila Bulletin for a long time, for 5 decades now, Mr. Ray Panaligan for the Manila Bulletin, one of the founding members and officers of the JUCRA. The sixth, whom the Chief Justice had already earlier acknowledged, Attorney Lorenzo Erin Tañada III for UNTV, a former 3-term member of the House of Representatives, representing the 4th District of Quezon, and former Deputy Speaker in the 15th Congress. He now serves as the Manager for News and Public Affairs of UNTV 37 and co-hosts several programs over UNTV. 7th, Ms. Arlene de la Cruz for Radio Inquirer, veteran journalist who has experience in television, print, and radio. Currently, she's an anchor and commentator over Radio Inquirer. The 8th, Mr. Joseph Morong of GMA Network Incorporated, the reporter for GMA Television covering the Supreme Court, among other beats. He's a member of the Justice and Court Reporters Association. I understand that he was earlier awarded the 2015 Marshall McLuhan Fellow for Media Excellence.
Wow. Congratulations, Joseph.
The 9th, Mr. Virgil Lopez, a reporter for Sunstar Manila covering the Supreme Court. He's a member of the Justice Reporters Organization, or JUROR. The 10th, Mr. Joel Ginto is a member of the Foreign Correspondents Association of the Philippines, or FOCAP. He writes for the Agence France Presse. 11th, Mr. Mark Meruenas for GMA News Online, the reporter for the online portal of GMA News, currently assigned to cover the Supreme Court. He's a member also of the Justice and Court Reporters Association, or JUCRA. The 12th, Mr. June Samson for DZAR, the reporter for Angel Radio, assigned to the Justice Beat. He's a member of the JUROR, or the Justice Reporters Organization. And the last, Mr. June Perfecto, a reporter for the Philippine News Agency, a member of the Justice Reporters Organization or juror.
Okay.
As agreed upon previously with the members of the panel, each member of the panel can ask 2 questions. They have the option to ask both questions in the same round or 1 question per round. As time permits, we shall also take questions from the public through our Twitter account at SCPH_PIO, hashtag AskCJ The first question will be asked by Mr. Ed Lingao.
Good afternoon, ma'am.
Hi, good afternoon, Ed.
Good afternoon, ma'am. My question has to do with the decision on the bail of Senator Enrile. Now, I understand that Justice Bersamin has registered this complaint, so I tried to craft my question very carefully. You've adopted the dissenting opinion of Justice Leon and you and 2 other justices. Does this mean, ma'am, that you have adopted the opinion of Justice Leon in its entirety, inclusive of all the arguments and the manner by which the arguments are presented by Justice Leon? That is the first question. Should I ask the second question already? Or?
Up to you.
Well, it's an unqualified concurrence with the dissent, so
Yes, ma'am.
that's it.
So that means it's in entirety.
Well, that's already a complete answer, Ed.
Do you want to ask your second question now or later?
Then I shall ask my second question then. There's been a push and pull of the budget of the judiciary in the past. For example, last year, you were talking about the 12 billion peso reduction of the proposed budget in the GAA. So there's been a consistent push and pull of the budget of the judiciary. Curiously, the judiciary's been getting what they call loose change. And a significant amount of the budget of the judiciary appears to be coming as well from, as you say, development partners. These are in many cases external partners, bilateral and multinational organizations. First of all, I'm wondering, obviously you see the need for more funding, but are you getting, do you think at this point, the support that you need from the executive? And secondly, do you think that the reliance on multilateral external institutions would have any implication or impact on the independence of the courts?
Those are 2 questions, Ted. What do we do with this? I have the option of answering only one,
Yes, ma'am.
right?
You have the option of answering only the
all right.
first.
In fairness to the executive department and the legislature, they have been actually responding positively. Of course, I don't think we will ever cease in pointing out to them that there is such a dire need to fund even more, so that at a certain point in time, we can say that even reform projects, which are very innovative, we need not go to the development partners to undertake them, because these go beyond the ordinary operating expenses that we usually allot. But we understand also, of course, that this is also the first time they have allotted 210 million for the capital outlay for the building of our halls of justice. So with respect to the infrastructure program for our lower courts, halls of justice, I am already content with the fact that they are giving us this year to show whether we can in fact build courts as efficiently as we promised we can. In other words, it is incumbent to us to show accountability for the funds. But I think that I had been very forthcoming in telling them that the needs of the judiciary are much larger than what had been proposed by the National Expenditure Program.
Pertains to your statement a while ago regarding the anti-corruption efforts of
Yes.
the judiciary and SC. Time and again, case fixing and justice for sale issues have been raised against the judiciary, ma'am. Lately, it surfaced. What are the proactive measures taken by the court to address corruption issues, to curb corruption in the judiciary? I'm talking about proactive measures, ma'am, because you already mentioned the penalties imposed, the administrative proceedings, so it's more on the preventive measures.
Okay.
In line with that, ma'am, I cannot avoid but ask for an update regarding your investigation into the case-fixing controversy. In July 2014, the Supreme Court ordered the CA to further investigate 4 judges. This, of course, is an offshoot of the Ma'am Arlene controversy. as a product of the first report of the Leonen Committee. So what is the latest on that? And is it true that Justice Leonen has recused from that committee, ma'am?
With respect to your first question, that posted a photograph of a justice of the Sandigan Bayan together with a famous litigant. And on the basis of his statements that he had asked me actually to investigate him, I then really asked that an investigation be conducted. That was a motu proprio action. So that is, in a certain sense, active. I am just not at liberty to tell you, but when I see that some of your reports have more meat to them than the usual complaint, I actually asked some of the officials in the Supreme Court to find out more. And these attempts to extract what I can from what is fed the court, from what I see, has resulted in some positive developments. So at the right time, we will be announcing the results of the investigation of some inputs that you had actually planted. The identity of the judges, I have to be very quiet about. But beyond that, I am trying to look for red flags. I have asked already some former members of the judiciary and some technical people to put together a study on how we can already identify patterns of corruption. In the process mapping that we are doing right now for all organizations, from the clerk of court and bank all down to the lower courts, we have already tried to identify at which point there can be human mediation that commands a price. So I am for the electronic raffling, and I'm trying to find out to what extent electronic raffling can be conducted all over the country. I have requested Attorney Ted to continue to give me, we are trying to create an FOI system within the judiciary. The only request I'm making is that such revelations do not interfere with the required independence of adjudication. In other words, when you have the electronic court system in place, you can already actually access the status of cases. And you know, if you are monitoring cases long enough, you will somehow be able to be able to smell out something fishy. When there is an electronic, where there is an appearance of undue haste or undue delay. And you can already tell me who are the inefficient judges, because sometimes inefficiency can make one vulnerable to corruption. So usually if a judge is not very competent, the judge is also vulnerable. So that's why we have to have more and more competent people. We are looking at our training program in PhilJA, and we are trying to create a monitoring system. If the seminars and training that they are undertaking really translates to correct behavior. And in our survey forms that I have already informed you about, when we ask people about conflict of interest situations, possibly asking them to detail financial entanglements even by members of the family, that is actually also a test of how far people are willing to be examined if they wish to join the judiciary. Of course, it's a new culture we're trying to introduce, and I have to get the buy-in of my fellow JBC members, and I have to persuade the public, including you, that our very inquisitive process now in the JBC is not really intended to intrude into the privacy of persons, but rather to prevent potential conflicts of interest which will impede the independence of judges. So, from the JBC level to the PhilJA training level, And the OCA right now is really trying to find out how they can improve their investigation other than a paper-type investigation. And I am trying to create a culture where the norm and it is popular to already live a simple lifestyle. If we can take away ostentatiousness and extravagance as a life goal from those who are aspiring to be members of the judiciary, and if we can allow them to appreciate a simple life because of the deeper internal meaning it can impart to them and to their families, then I think we will have a more proactive system of inculcating the right values in the judiciary. You know, in some jurisdictions, I was told that to be part of the judiciary is to live the life of a monk. Well, I don't think Filipinos enjoy the thought of a monastic life, but perhaps a semi-monastic life, where our companionship can be already derived from fellow judges, the families that we are surrounded with, and we lessen our associations with social clubs and especially political organizations, and also very complicated business entanglements. That is where we should be headed for INA. But it's a long road, and what I want right now is to have the ability to pin hard evidence on them. As you know, we are showing already a firm hand in resolving these administrative cases, not only of judges, but also of court employees as well as lawyers, including the notorious practice of abusing the notarial practice. So we have to examine so many systems that lend to corruption. And we have to ask the basic question of why is it so easy to perjure in our system. Ultimately, it is also that. We have to find the answer to that. A lot of soul searching, a lot of systems analysis, a lot of systems improvement, a lot of buffering up the ability of our people to do a good job at investigation.
Ma'am, in connection
That's-
to that.
That's,
Actually, that
the
was
second-
just one question, ma'am, because
yeah. But the answer was good
the
enough
update
for
on
two.
the Leonen
Very
Committee.
long.
Ma'am, the initial report of the Leonen Committee was
Okay,
in...
I know. So,
Yeah.
with respect to the investigation regarding a certain fixer, well, there was already a committee report, and that committee report has led to 4 administrative cases being born. I cannot disclose the details because these are now confidential administrative cases. So please be patient because these are now formal processes in place. And I do not want to preempt Justice Leonen's participation, but eventually when the resolution on the 4 administrative cases come out, you will be able to see whether he still participates or not.
But he's still the chair of the committee.
That is now put on hold because it has already borne 4 formal cases. You know, when an investigating committee has done significant part of its job, sometimes it has to give way already to formal administrative processes, and that is where it is now.
Thank you, CJ. Are you asking your second question, Dina?
That's the end.
No, ma'am, it was just one question, but the second question was really
No,
something.
I have to be fair. You know, I did that to Ed, so
Okay, it's
no,
okay.
no. When we come up, possibly for another round.
Okay, it's okay, ma'am.
Okay, well,
Ed
now-
might think that I am an unfair person.
No, because that was about corruption, ma'am. Updates on the anti-corruption campaign, but that just covers one sector, one particular.
maybe next
Maybe
round,
later,
yeah.
yeah.
We go to Donna Cueto Ibanez of Net 25.
But thank you, Ina. I know you want to write a full story on this, and go ahead and be brave. Sige. Donna?
Good afternoon, ma'am.
Hi,
and
Donna.
congratulations on your accomplishments. We're so glad to hear about these. Ma'am, do you see the judiciary's role still evolving, and what are the challenges that you think you have to face in the next few months before the term of President Aquino ends?
The judiciary has a long way to go, and it will take a lot to make it evolve into the ideal state that it should be occupied. Imagine an institution that is insulated from politics, that is insulated from the influence of big business, that does things on a very regular, automatic basis, yet with enough compassion for the human condition, especially those of the underprivileged. We have a long way to go, and before, it used to be thought that we were a privileged class in the sense that we were usually beyond public scrutiny. But you can see that we are opening ourselves more today. We are disclosing more records on our website. We have a full annual report, and we are submitting everything to audit. We have opened the proceedings of the oral arguments to live audio casting and recording them even. We have summarized even the most salient points of the most controversial petitions that are before us. We have tried to feed more information to the media so that everybody can appreciate the fact that what we really want is an improved level of understanding. Ultimately, let me tell you my end in mind. It is a judiciary that has such an influence on the rule of law that the two other branches of government, the political branches, are so mindful that anything they do, even in the name of politics, has to be within the ambit of what is constitutionally designed. And it is not only a defensive way, but it is an active seeking of trying to fulfill the constitutional design, where you have a Congress that is fully cognizant of its duty to really have laws implemented and designed, and something that can be actually implemented rather by the executive department. And the judiciary finding out if the checks and balances designed by the Constitution, not only among the three great branches, but also by the independent constitutional commissions. You have the COA, Civil Service, the COMELEC, and including the Commission on Human Rights and the Ombudsman, if they are all working well. So that you have a government that functions with the correct efficiency, but an efficiency that is still within the bounds of what is called the rule of law. And eventually, if you can imagine that the powers of the Supreme Court, as designed in the Constitution, means to give us a say even in the matter of quasi-judicial rules of procedure. And if we can talk to all the agencies that have quasi-judicial or quasi-adjudicative functions and tell them, you have to have a more proactive view of due process. You design a system so that it is more accessible. For example, why can we not persuade all those quasi-adjudicative processes to put more systems on technologically friendly systems so that access to justice is improved? If we can have a fair system of correcting and appraising the legal fees, then we all are on the same page, whereby, first, everybody understands what is expected of them. And the adage that ignorance of the law excuses no one becomes applicable only in very exceptional cases where people really are not mindful of what the law is. But because we have been having a very interactive and a very proactive educational and information system, you don't have people complaining anymore that they didn't know law in the first place, what is required of them. And if you can put processes in a way that seems accessible to the ordinary people. For example, I have not yet told you about our plans to revitalize the small claim system. What we intend to do is to have summary proceedings that are very simple, that are not made complicated by lawyers. For simple cases such as simple collection cases below a certain monetary threshold. so that we take away the high cost that is associated with having a dispute in court. I hope to make this system accessible. We hope to make this system accessible so that those who have a laptop or access to an internet anywhere can already find out what are the abilities they can have to work within the system. We must also never forget that we have 10 million OFWs, and that is part of the Filipino nation. Our system must be designed in a way that makes them feel included. So that is more than anything an evolution of a very dramatic or radical order, because we must have a new way of looking at things. It must no longer be a court that is passive and waiting for parties to finally come to them and file the pleadings. But look, the court is now even involved in court-referred mediation. And a judge, another judge, can even make preliminary analysis of the case and give advice to parties, not the judge that will hear the case, on the prospects of their cases if it would go to trial, to convince everyone and show everyone that there is always a cost to any process. So that if we are more proactive in this way, I don't think that justice is necessarily embodied in a case that has fully gone through all the technical proceedings all the way up to the Supreme Court. But when you look at justice, it is the ordinary sense of a person who has a way of having his grievance heard and adjudicated in a manner that will allow him to move on, because there is a fast closure. So that is real time. That is what we're trying to impart to people, that you can have somehow a semblance of justice being delivered real time. It requires an appreciation of technology. It requires an appreciation of the fact that our people are so diverse. It requires an appreciation of the fact that it is no longer time to just be locked up in our courtrooms, but those who have leadership roles and administrative roles must go out and reach the communities so that the communities can understand what we are all about.
Thank you, CJ. You asked your second question now? Okay, go ahead.
You mentioned before about you now have the funds to build your own halls of justice, your own buildings, and that's good to know. But do you still see, feel there are threats to judicial independence, to the SC's independence in particular? And what are those threats that should be addressed right now before they come up and become a big problem for you?
Okay. Correction, only some funds. Okay. For next year, we have been given, if I'm not mistaken, 210 million. Okay, that's a good fund to start with. We hope to have around 10 halls of justice built with that money, and the detailed architectural engineering design for the major edifices in Cebu and in Cagayan de Oro. But let's set that aside. And you are talking about how to ensure that judicial independence is strengthened, not only by the fact that starting next year, we will have money for lower courts HOJs. We have to be frank with all those who are aspiring for a position in the judiciary. Whether they are willing to commit to the people that regardless of who appointed them, they will be independent. And we will have to ask them a track record of being able to say no even to those they have a lot of debt of gratitude for. Now, that takes a lot of soul searching on their part, because if they are asked frankly, and they do not show when they already have their judicial careers that they cannot, in fact, live a life of independence, that will weigh very heavily on them. So we need to have a very strong judicial and bar council that will have a lot of investigators asking these questions so that we can have a database that will already have a map of the interconnectedness of this person and whether that person can sufficiently divorce himself from that interconnectedness when he or she is appointed to the judiciary. As long as people are appointed by someone, then there will be speculation by the public that a debt of gratitude will always be owing. So what the judge must do is when he or she sits, he must show real character and show independence. We judges must have a way of showing how they can do that. We must be able to be frank among ourselves and say, we can do that because, first of all, sad as it is, painful as it is, I simply have to say no because this is my oath. So, I also have to continuously appeal to our people to come up with evidence so that we can rid ourselves of those who are weighing us down. In other words, if you have stories of and actual accounts of how money exchanged hands or how judges had been unduly influenced, then those stories must reach us. And I think that if we show leadership at all times, that we are willing to defend our decisions very, very thoroughly, very intelligently, and with full clarity, I think perhaps the public may believe that there is independence in our decision.
Thank you, CJ. Now we'll go to Tara Quismundo.
Hi,
for
good
her first
afternoon,
question.
ma'am. I have, just like Sir Ed, I have also carefully crafted my question.
Yeah, you are all careful. Eh? Thank you.
Ma'am, you spoke earlier about about how so many prisoners have yet to see genuine justice.
Yes.
And there was this very recent ruling on bail that has spurred a little controversy and some criticism towards the court. And for you, how should the country's courts interpret the rules on bail, especially the Constitution's Article 3, Section 13, in very general terms?
We have a case that will precisely answer that question. And because your carefully crafted question will directly impinge on that case, I cannot answer your carefully crafted question. So maybe you can have another try, Tara.
No luck.
Are you going to ask your second question now?
Yes, I'll
Okay.
try again with my second
Question
question.
number 2 for Tara.
Attempt number 2. Okay, ma'am. Ma'am, this very recent ruling has
She is
spurred
persistent, that's it.
some controversy, some criticism, and even a degree of distrust among our people. I see comments on social media about what's been happening since this decision. So, what would you like to tell the public in this regard?
What I will tell the public is to wait. It's because I think there is still a motion for reconsideration. In all probability, there might be a motion for reconsideration. So wait, please. And Tara, thank you for that very carefully crafted question that allowed me to give a one-word answer.
Okay. Thank you, Tara. So for the next question to be asked by Mr. Ray
Ted, you have to treat Tara somewhere. You must try to avoid her talking.
Maybe a third question, ma'am, would be.
Okay.
Magandang
We go to
hapon po.
Kaka, Mr. Ray Banarigan of Manila
Thank you
Bulletin.
very much, Attorney Ted. Magandang hapon po. Magsasalita po
Ay,
ako
napakaganda po.
sa wikang Pilipino dahil
Tama po yung
ang
ginagawa
nagpapatanong po sa akin ay no-read na isang litigan.
Ay,
Kasi
importante
po
po
nung-
yung tanong na yan.
Nung isang taon po, ang nagtanong magsasaka sa inyo, hindi pa ba? Na hindi nyo rin sinagot Kasi hindi carefully crafted ang question. Ngayon po ganito, isa pong litigan, no red no right, ang nagsasabi na napakarami niyong reform ang ginagawa sa pag-improve ng delivery of justice sa mga korte. However, ang hindi no daw po, sabi nila, na na-address mabuti yung punctuality ng judges. Bakit po? So sabi niya sa akin, sige, sumama ka kaka sa sabihin ko man lugar. Sumama
Isulat
ka
niyo
sa
na lang
akin
po
sa isang
papel.
regional trial court dito sa Maynila. Sumama naman ako. Naka-schedule ang hearing ng 8:30, dumating po ang judge ng 11:30. Ang dami pong nagagalit na mga litigants. Marami pong irritable. O sige, pagsensya natin, baka sobrang traffic eh. Tawagan natin si Chairman Tolentino. Okay. So, nag-set ulit. Nagpunta uli ako. Tingnan mo uli ka ha? Nag-set ulit ng 8:30, 10:30 dumating. So, yun hong lahat ng reformang ginagawa ninyo. At natutuwa yung mga magsasaka, litigante, kung sino man, natutuwa, para hong yung personal namang reform sa mga personal natin ang hindi namamatch yung lahat ng inyong sabina, computerized system, etc. etc. Meron ho ba tayo magagawa doon na
Okay, meron
dapat
po.
pag sinabing 8:30, nandun sila kaagad?
Opo.
Marami hong nadidismaya.
Okay.
Natutuwa sa inyo, sa reforma nyo, pero nadidismaya sa ginagawa ng iba. Hindi ko naman ito nilalahat, no? Na late, tapos pag na-late yung litigant, iko-contempt. Pag na-late ang judge, anong gagawin? Yung po ang tanong. Salamat po ng marami.
Kaka, maganda yung tanong mo kasi tama po yan na magagalit po talaga ang mga litigants sa ganon. Kaya si Ted po, pagkatapos nito, hihingin po ang isang papel na may nakasulat po kayong mga detalye po, no? Hindi po ako nangingiming, humingi po ng detalyo sa inyong mga journalists. Kung meron po kayong kailangang bagay na malaman ko, ipaalam niyo po. At andyan po si Attorney Ted para dyan. Kasi hindi po tama nga yan. Magsa-schedule siya ng 8:30, darating siya ng alas 11 pasado, medyo kakaiba naman pong ugali yan. Kung mayroon na po tayong unang-una yung biometric system para po sa attendance at pangalawa yung minutes na recorded ng proceedings na may certification at may enter na po yan sa system natin, malalaman po natin at matratrack ang performance ng mga huwes. Pero maganda ho yan kasi kasama na po ng inyong pagre-report in public sa inyong mismong nakita ay isa na rin pong warning sa lahat po na ang expectation ng public ay napakataas. Pag sinabi yung 8:30, dapat nandun na kayo ng 8:30. Mayroon pong mga dating mga liderato noon na gumagawa po ng surprise visits nga. At in fact, ini-encourage na nga po akong gumawa ng mga surprise visits. Kaya lang po, napakadami lang po ng aking mga appointments ngayon, kaya hindi ko po magawa. Ngunit, ma-assure po kayo, hihingin ko ang iba yung pagtutok ng court administrator, ng mga tao niya, at ng mga judicial supervisor sa bagay na ito. At pupulungin ko po ulit ang mga executive judges para sabihin sa kanila na ito ay hindi nalilingid sa kalaman ng publiko na mayroong mga ilan sa atin na nagbibigay ng masamang impression sa publiko dahil sa ganyang behavior. Hihingin ko po ang executive judge na magbigay sa akin ng report tungkol sa mga bagay nito. At salamat po. At pinahayag nyo na mayroon pa haong depektibong behavior na ganito.
Salamat.
po.
Thank you
Kakatatanungin
po.
mo na yung pangalawa mo o mamaya na? Ngayon na.
Pwede ituloy ko na lang.
Sige pa.
From
Second
my
question po.
editor, Madam Chief Justice, may sinulat ho kami yung asking the Supreme Court to compel the Ombudsman and the Department of Justice, the Ombudsman first to investigate and thereafter file a verified complaint for impeachment against the President, and directing or asking the Supreme Court to compel the DOJ to investigate immediately and expand the investigation into the DAP and PDAP. Naka-agenda ho yun next week. Thank you.
Hindi ko ho pa alam ang agenda next week. Titingnan ko pa po yan sa aking mesa ko nandun. So, hindi ko po alam. Maganda na lang po't hindi ko alam. Kaya maganda diretso ang sagot ko sa inyo.
Hindi rin carefully crafted.
Apo.
With that, ay walang sagot. Pwede bang may third question?
Okay, dalawa lang kaka
Okay, thank you.
Thank you. Salamat kaka. Now we'll go to the next one who will ask, Erin Tanyada of UNTV.
Happy anniversary, Madam Chief Justice. It has been mentioned by the Supreme Court that deliberations of the Supreme Court and bank are supposed to be kept secret. Don't you think that this contributes to the mistrust of the public on the Supreme Court in the light of the clamor of the public for transparency and the need of FOI? And is it not time to change this rule?
Yung pag-uusap po ng confidentiality na yan, kailangan naman hong tinan sa konteksto ng bakit nga po kailangan ng confidentiality. At sa kulukuyang pinag-uusapan naman po yan. Kasi noon pa naman pong 1984, mayroon na pong isang huwes na napakataas ng respeto ng publiko na nagsiwalat po ng mga bagay ukol sa deliberasyon. So ano po ba ang purpose ng confidentiality? Kailangan ho sigurong tanungin muna yung unang tanong na yan. At meron naman ho kami internal rules committee na rinireview po namin ang lahat ng mga rules namin. So pinag-uusapan naman po yan at hindi ho ito bagong usapin. Noon pa ho namin yan isang concern, ano ho ba talaga ang aming gustong ma-accomplish sa confidentiality.
Are you asking your second question? Sige, second question.
Second question is with regard to, well, elections are coming next year. And there are still pending 2013 election cases with the Supreme Court. Will the Supreme Court decide this case within the year, or will it just let it become moot and academic since the 2016 elections are next year?
We are actually expediting all the election cases. Nasa priority list namin. Talagang iniisa-isa na ho namin. So I hope that we can come back to you and say that all 2013 election cases have already been finished. But note that they are a priority.
Thank you, Erin. The next one to ask will be Arlene de la Cruz, Radio Inquirer.
Ma'am, I'm not the Ma'am Arlene on the story. Good afternoon, ma'am, and happy anniversary. Ma'am, I've written 8 questions for you, but I'm only allowed 8 as the rest of the members of the panelists here, and I hope this is also a carefully crafted question. An attempt. Without referring to any case or issue, is it unacceptable practice amongst members of the magistrate to openly discuss, expound, or even defend their positions on juridical expertise, whether they are pro or against a certain ruling? Is there any restriction on publicly speaking about a case already decided upon by the majority? Please enlighten us. An attempt.
Related po yan doon sa sagot ko kay Attorney Tanyada. So, I will copy it verbatim and yan ang sagot ko po sa iyong tanong.
Verbatim. Okay. Carefully crafted question with the same response. Ma'am, there is a question that there was a runaround on the SC's interpretation on the DAP, or the Development Assistance Program, and also on the issue of PDAP. It appears that they are still in the budget of 2015 and 2016, as alleged by some legislators. The question is, will the Supreme Court issue a clarificatory order on its previous rulings on DAP and PDAP to make clear or ascertain the constitutionality of the provisions?
If that is the same case that you're referring to, that Mr. Panaligan was referring to, that I don't even know whether that case is already in the agenda. With respect to your general question, whether we are going to make any ruling on the matter, I don't want to preempt the court. Wait.
Okay.
Wait lang po, please.
Sige. Salamat, Arlene. So those were your 2 questions. The next one to ask will be Joseph Morrow, GMA Network.
We will try again, ma'am. But I'm not interested about the merits of the Enrile case, because I know your answer is going to be it's a pending case. But I am interested, and I think the public is also interested, in the implication of the decision. They say that what the Supreme Court says is the law of the land, becomes the law of the land. In that decision, the Supreme Court, at least the majority, said, if you're old, you have diseases, you can file for bail, even if it's not a bailable offense. Is this a precedent-taking decision?
Ang sagot dyan, actually, nasabi ko na kay Tara una eh. Wait. Okay. But to give you a longer answer, I am not a sociologist, so I cannot understand the implications that you're drawing on society at large. So I cannot predict what will happen. If that is your question, no?
No, that's not my question.
Oh, galing talaga niya. That is
So since you misunderstood my first question, I can rephrase it, right? Ma'am, to
Okay,
rephrase
okay.
the first question, is this a precedent-taking decision?
then you have to really wait. So thank you.
Okay. Second question.
So you ask your second already?
No, rephrase. I'll ask the second.
Okay.
Ma'am, in your so far 3 years in the Supreme Court, there have been landmark cases where the Supreme Court voted unanimously DAP, PDAF, RH law, cybercrime law, but in cases where there is not a unanimity among the justices, at least in the past 3 decisions, you voted in the minority. For example, sa Torre de Manila, you're 5 in your 5 sa 8-5 number 5 sa 5 kasama ka sa 5 sa Bill of Particulars kasama ka pa rin sa minority, and then recently sa Enrile Bail you're one of the 4. Do you agree that do you think that a Supreme Court Chief Justice needs a clout among the members of the court to be effective? And what does the Enrile situation say about your relationship to the other justices?
Just to clarify first, no, that this is not in response to the question. With respect to the Torre de Manila, TRO, it was just an interlocutory order. Okay, so hindi decision yun. So it doesn't have any bearing on the merits. Now, with respect to the last 2, where you said I am in the minority, and the relationship that the Chief Justice, the role that the Chief Justice must have. The role of the Chief Justice is very clear in the Constitution. It is to vote as independently as she can, with all competence, with all probity, integrity, and of course, independence. It does not matter whether her vote will be cast with the minority or the majority. Because if she shows herself as a Chief Justice that is afraid of being in the minority, then that is a signal to the rest of the judiciary to allow their decisions to be influenced by whether they will score a win or not. That is not the point of being a good judge. A good judge is one judges according to the best lights of his training and his conscience. And she must never be afraid even if she is alone. If she shows that she has fear because the numbers are not with her, then she just has shown the public lack of courage. And the Chief Justice must be first in that respect.
Thank you, CJ.
My relationship with anyone in my profession will be dictated by that principle.
Thank you. Thank you, Chief. Thank you, Joseph. The next one to ask will be Virgil Lopez of Sunstar Manila.
Good afternoon. Hello. Good afternoon, Chief. Good afternoon, Chief Justice. Congratulations on your 3rd anniversary.
Thank you.
In relation to Ms. Donna's question earlier, is there any way for the Judicial and Bar Council to actually only nominate perceived to be independent candidates to judiciary?
The impression I have, especially from the bar, is that they have appreciated the list of nominees to the tertiary level courts and the Supreme Court that have been forthcoming from the Judicial and Bar Council. So I think that there is already improvement in that sense. But there is more that we can do. Because if we are able to really clarify for the judges what it means to avoid a conflict of interest situation, that is, you want to be a judge, then this is the kind of life you want. We will scrutinize all of those aspects that will possibly affect your independence. And if you find it too intrusive, maybe the judiciary is not for you. Maybe this life is not cut out for you. You can go to other ventures. There are a lot of good activities to do other than judging if you are a lawyer. So, if we can strengthen that, I think we can really somehow come to the point when judges will be set apart. In terms of Filipino culture, you know, Filipino culture is so heavy with pakikisama and utang na loob. We have to tell and we have to really make the public internalize the concept that the judge must not be expected to be a person of pakikisama. And her gratitude must be shown by exercising independence. It is not by accommodating the request of the powerful or those who help secure the appointment for her. If our public can embrace that, and all those who are in law, who are pushing for their relatives or who themselves are aspiring to be judges, to understand that from day one, you are not allowed to live a life that will use the usual norm of pakikisama and utang na loob, but you are to be set apart, then we can reach that point where we will be very proud of our judiciary as a whole. Right now, our recent decisions show that we still have a lot of cleansing to do.
I'll ask my second question.
Thank you, Chief.
Yeah.
Second question.
Apart from the release of silent summaries and financial reports, what are the other transparency measures the court is looking at or would like to come up in the coming days or months?
If after we are finished with our case decongestion program, then I hope that when it is already fair to judges for their cases to be really trackable and monitored, I think that will be a welcome development for you. The reason why we cannot just release all the summaries right now and all the details of the cases is that you will be shocked that some courts still have 4,000 cases. And you might say that why are the cases with this particular judge delayed for so long? It might not be fair for us to release the list of cases of those judges simply because some of them have just been, in fact, newly appointed to those salas. We hope to come to the point where each judge will just have an average caseload of around 300. And by that time, maybe we can make continuous trial really mandatory for all cases, for all types.
Thank you, Virgil. Thank you, Chief. The next to us will be Joel Ginto of Agence France Presse.
Good afternoon, ma'am,
Hi,
and
Joel.
congratulations on your third
Thank
year.
you.
My apologies, there's no other way to phrase this question. When can the public expect a decision on the EDCA? How would you describe the deliberations on the matter? And if at all, how are the developments in the South China Sea factor into your decision making?
Wait, Joel, that's 3 questions.
On one topic.
I will only answer the first.
Okay. Only answer the first.
I cannot, the first in relation to the second and the third. Okay. I cannot preempt the court. I am sure that everyone understands that we are trying to show that we can issue decisions in a timely manner, but I cannot make any announcement that will preempt the court. So thank you, Joel, for bringing your concern foremost here at this table.
Are you asking your second question now?
Yeah, yes.
Okay.
You also mentioned the Maguindanao case.
Yes.
Ma'am, what gives you the optimism that the defense and prosecution panels would be able to rest their case by year-end when the general impression is the case has moved excruciatingly slow with the elder Ampatuan having died a couple of weeks back?
What gives me reason to be hopeful?
Yes, ma'am. And what would a
It is
decision...
excruciatingly slow for the victims' families. That is not debatable. It is painful. There must be closure to this. But what gives me reason to be optimistic is the pace at which I see our judge disposing of the matter. And the commitments that they have made in open court, and these are of public record, I think the public can exact delivery on those commitments. So you already know, on the basis of the information you have a way forward to make sure that, in fact, that commitment is delivered.
You also mentioned the global significance of this case. Ma'am, what would a possible decision say about the pace of judicial reforms?
Wait, Joel,
6 years after?
Joel, that's your third question.
Yeah, at
I'm
least
sorry, sir.
so I know that now he will continue to reflect on this question. You can ask it next year. No, Joel. That's When the time comes, when the decision is handed down, then when it is proper, only when it is proper, then a statement may be forthcoming from me. But I will not preempt Ted because Ted has to advise me on that.
Thank you, Pa. Thank you, Joel.
It's okay.
Next to ask will be Mr. Mark Merenes of GMA News Online.
Mark,
Good
hello.
afternoon, ma'am. It will be the elections in 9 months. And of course, there will be a change of administration, new people in the government. And of course, with that comes a new set of appointees in the judiciary, specifically in the Supreme Court. Do you have any fear that the reforms that you have instituted or started would get derailed or suffer a setback with this new people that would probably be sitting in the after the elections? And how do you plan to remedy, if ever, these reforms suffer setbacks?
Okay. This is how I prime my mind when I look at all the things that must be done in the judiciary. Any setback is not reason for me to stop working. In other words, in fact, it will only spur me to do things in a more determined and intelligent manner. Now, many of the reform programs, nearly all, are already institutionalized. In other words, they carry the full support of the NBank. And for example, the process reforms involving the use of technology, the infrastructure programs, the systems improvements, I don't think those can be overturned by any new entrant who wishes to upset the system. That new entrant will be extremely foolhardy to try to unravel the systems reforms that are already taking place. So that the entire menu of action plans that have been drawn up are quite comprehensive. From organizational re-engineering, systems re-engineering, financial modernization, automation of all processes, and a revitalized selection and a revitalized nomination process. Those are very, very dramatic changes. Now, I cannot speculate on the next batch of justices, even if the new justices will be 11 in all for the next president. What gives me actually hope is that if the public likes the trajectory of reform, then I think the impetus will be so strong that you should not stop what is already happening. That is the reason why I want to participate in monitoring these processes that are currently taking place. If that prisoner in Davao City cried, if you already have selfies of automated hearing outcomes, if you already have all of these stories circulating, and if lawyers and litigants are enjoying the greater freedom that efficient processes give them, I think the demand will be there. You will demand these, and I want you to continue demanding these. And I am encouraging you to continue demanding these reforms. So many of these cannot be turned back anymore. I hope that money will continue to be given us by the legislature. I hope that the public will continue to help monitor all of these gains, all of these successes, and at the same time, as Mr. Panaligan did, try to help us identify areas that still need to be rectified, help us craft even better solutions than we have already identified so far. If the public is with me, and I hope they are, Mark, then it gives me greater reason to commit to the public that we will eventually, we, meaning the judiciary, will eventually reach the point that we can provide the gold standard for public service. So, I am that, well, the determination is there, Mark.
Thank you, Chief.
Thank
Are you asking a second question? Okay.
Chief, this is in relation to the question of Attorney Erin about poll protests. Can you give us an update without going into the merits of the case about the pending protest from Rojas? It's the 6-year-old protest, poll protest against Binay. Since it's already the elections in 9 months' time, what would happen to the case? Would it get mooted? And does the Supreme Court plan on prioritizing the case?
I think that there are pending motions that are still being resolved right now. And I think that there is not enough funding for some parts of the protest because, you know, it requires payment of certain fees. So I will leave it to the member in charge to act on those. And the moment that we are able to resolve it, Ted will immediately announce what will happen. There are things that are not within our control completely in an election protest of this kind.
Thank you, Mark. Thank you, Chief. The next to ask is Mr. Jun Samson, DZAR.
Good afternoon, Chief Justice, and happy anniversary po.
Thank you, June. Thank you.
Just like Ms. Arlene de la Cruz, no, I had questions here. Pero isa lang muna, no. There are times po na may mga leakages. Minsan, nauna pa lumalabas agad sa media, no. Obviously, galing po sa insider. How do you react on this matter, ma'am?
Ang sagot ko, yung sagot ko on...
Ma'am, wait.
Kay Joseph ba yun? Yung sabi ko, pinag-uusapan pa namin. Yung context noon is we really need to look at our rules. Okay. Do we need to change our rules?
Next question ka na? Or next?
Mamaya na
Okay
lang po, sa round
Second
two
round na? Okay. So, yung huling magtatanong ng unang tanong niya, June Perfecto of PNA.
Good afternoon, Chief Justice. Congratulations po sa happy anniversary. Ma'am, nasabi niyo kanina yung tungkol sa budget ng judiciary. You were asking some 26.6 billion. And there are reports, some salons are proposing to increase the budget of judiciary to about 1% of the 3 trillion proposed budget of the national government. How would you react to that proposals of some lawmakers?
Okay na for now yung 26 billion. Pero totoo naman talaga, kung talagang full, kung full complement, yung if the experience that we want our people to experience is everything is a continuous trial basis, walang delayed case, mabilis lahat. Kasi tandaan mo, iilan pa lang tong electronic courts na nagawa namin. Hindi pa lahat, And the money that we have used is really not from the national government. We still have to compute the entire financial requirement to make all court processes automated nationwide. So, and then we have to maintain that for the longest time possible. Di namin pwedeng pigilan. The moment it's automated, we must always have very good connectivity. And of course, the contracts for that runs into the hundreds of millions if you have a nationwide connectivity system. So, eventually, we will be able to show that the dramatic increase in the national budget, because the national budget also dramatically increased to 3 trillion. I don't think there has been any ramp up this fast as we have seen in the past few years. When we are fully capable of absorbing the money, because we have to set up all the administrative systems so that the monies are appropriately used, because one of the major problems, for example, in spending in this country for public spending is the ability of the agency to do the appropriate procurement. So I'm looking at our procurement system and how much can it really absorb. I'm not going to ask more money than then we can actually utilize. That's unwise use of money. Yes, we will get to the point that we will need 1% of that budget that is around 3 trillion, but not for next year yet. Thank you, June.
June, are you asking your second question now or next round na? Okay. There are three members of the panel who have one more question left, but we'll take a few questions, ma'am, if you don't mind, from social media.
Yeah.
First question, from SC Watch PH. Do you follow social media and read the comments about particular issues about the court and reactions to decisions?
I don't actually spend time monitoring that. First, because I don't have enough time to be monitoring social media discussions. So I have to tell you that actually I get feedback on what is happening in social media in a condensed version from some trusted persons, one of whom is Attorney Te. And the second part of that question is?
Do you read the comments about particular issues about the court and reactions to decisions?
I am able to read some comments of the news when I read them in their online version. That is the most that I can do, actually. And yes, I read the comments, and that's all, factual.
Yes, ma'am. There is a second question. I think this is probably a law student because it is very direct. From @lawstudents PH, what advice can you give to law students and aspiring lawyers on how to handle challenges and pressures and things that are out of our control?
The first thing that I have to advise young law students, meaning those who have not had much experience even in another profession before they entered law school, is that there will always be a dissonance between theory, the lessons that you get in the classroom, and what actually happens out there in the field. And when you encounter this dissonance, do not be disheartened, but rather be bold enough to ask the right questions. So it requires a lot of wisdom to do that. So that you must be actually very discerning in your choice of a first job. Because if you get exposed to the wrong side of our trade, and it disheartens you so much that law itself loses meaning for you, then it would be a very sad day indeed when that happens. So you have to be careful what you ask for. Are you looking for meaning in life, or are you just looking for material advancement? If it is the second, and the most efficient track to get there might be one that is strewn with the trickeries of the trade, then you will be in for a shock. At one point, you will lose your appetite for the more noble aspects of law. So be very discerning. Don't ever think that the lessons and the theories are what they are in real life. But never lose the real reason why law was created. It is a beautiful profession. It is meant to try to bring good to an unjust world. It is intended to create order in what would otherwise be a chaotic world. So, with all the energy and creativity that you have, you can keep on demanding that we have more just laws and we have more just processes that support those laws. Many aspects of our legal system have been unaccounted for. For example, law students can look at the plethora of laws that are existing in our statute books, many of which no longer make sense. Law students have the time, have the ability to try to ask the body politic to bring sense and order again. Many laws have not been implemented. Many are so outdated. Many contradict other laws. Those are areas of inquiry that a law student can really devote her time to. At the same time, if law students can try to galvanize themselves and keep on encouraging each other to hold true to that idealism which first impelled them to seek law as a possible lifetime profession, then there is strength in numbers. Do not be disheartened by what you see. It is a lifetime process. Trying to contribute to nation building is a lifetime process. We don't stop at one debacle. A debacle only gives us even more reason to persevere. At the end of the day, we all have to ask ourselves the question of meaning, whether we have faced it or we have allowed ourselves to live a banal life.
Thank you, ma'am. We'll take one more question from social media, then we'll go to the second round. This is a very direct question from @GTINSF. How can you help Zamboanga City have additional RTCs to speed up cases for justice due to overcrowding in detention?
Yeah, actually, we have problems even on an operational level. I don't actually know the number of courts that we have right now in Zamboanga. You know, I have not even discussed with you the problem of overcrowded jails. Now, the number of inmates in jails is not something that the judiciary dictates, but it is a function of the number of informations that are being filed by the system. We never had an analysis of the supply and the demand gap with respect to the number of jails that we need in relation to the number of filing of criminal cases. We don't even have an analysis of the increase in the demographics of a particular city in relation to the infrastructures for justice that are available in that city. Never. So this is the reason why we, meaning I, the Secretary of Justice, the Secretary of Interior, have to come together, and we agreed that we have to create a map for all the cities and municipalities where we plot the population, current and projected. And we have to have a formula that will project the number of informations that will be continuously be filed in that particular area and the amount of spaces in the detention centers available in that area. We've never had that exercise. This accounts for some jails having a 1-to-7 ratio. And I would not be surprised that Zamboanga will have a very, very terrible situation right now. So it is a wake-up call to our people. Are you willing that our prisoners right now are taking turns sleeping simply because they're on the floor, simply because there is not enough room for them? Some will need to stand, some will need to sleep, but they take turns. I don't think any system can abide that injustice. Every prisoner needs to be treated like a human being. Our jails are not able to treat them in that manner. So what does it mean? It means that really the justice sector has been historically underfunded. You know, they think that when you're a lawyer, you're good at litigating and everything, that you already know and you're able to deliver justice. But there is more than that. A human being is not one whose sense of satisfaction springs from the fact that the judge is going to make a pronouncement favorable to him. During the period when he is awaiting that judgment, is he being treated the way he should be? And in order to come to that decision as to how to allocate the logistics necessary, we have to have engineers, plotters, statisticians, analysts on board. We make use of the best of social sciences so that we are able to provide humane conditions for detention prisoners. So the system has not been sufficiently analyzed. There has not been a sufficient plan for the entire justice system. And we are actually just at the starting point of trying to come together and have our numbers correct. But before that, I will have to commit to that participant from social media that yes, I will look at the Zamboanga numbers immediately. That is the reason why we need to look at how we address the problem of impunity and criminality also. We have to find out why our laws are not being implemented. We should not be afraid of these discussions. In fact, we should be occupied by discussions on why our laws are being flouted so openly. So that problem is being addressed. I need the cooperation of the DOJ and the DILG. If there are local jails, of course, the LGU concerned, and the support of Congress and the executive, the Office of the President, for those problems to be addressed. We have a long way to go.
Thank you, Chief. We'll go now to the second round. Based on my notes, there are only 3 who have 1 question each. So we will start according to the order which we started. And so the first to ask her second question is Ina Reformina of ABS-CBN.
Ma'am, finally. Based on the experience of the court, ma'am, with our shift from manual elections to automated elections nationwide since 2010, how has this affected the resolution of election-related cases or protests before, for example, the PET, ma'am, from the manual to the automated system? Because, for instance, in the case of Secretary Rojas, he is requesting for random manual sampling, but the 2010 rules of the PET do not provide for that. So are we now trying to transition in terms of resolving election-related protests with that particular premise, of course, that we have shifted our system of elections or polls?
I have actually asked the Philippine Judicial Academy to prepare a training program for our election judges, and this training program will be launched in November. But it will depend on the new rules to be promulgated by the Commission on Elections. We're still waiting for those rules to come out. And whatever lessons that we have had from resolving 2010 and 2013 elections, we will have to look at the new training program that we will be creating. So I cannot preempt right now how we are going to resolve the various motions that are still pending in the court. I think that I have heard stories, I have heard accounts that with respect to the HRET, it has become easier. But so I will not answer you in relation to the pending PET case.
Thank you, Ina. Thank you, Chief. The next to ask his second question is June Samson of DZAR.
Good afternoon po ulit. Ma'am, remember nung naupo si Pangulong Noynoy Aquino, nauga ang judiciary hanggang sa na-impeach po si J. Corona. Ngayon pong pagtatapos na po ang termino ni Pinoy, ano po ang expectation nyo, especially pag iba na yung Pangulo, regardless kung LP or other party ang magiging presidente? Ano po ang expectation nyo for judiciary?
Ang expectation ko araw-araw trabaho kami talaga ng gusto, no? Kahit sino pang umupo dyan, parang ang premise mo magiging komportable ba kung ito o hindi, etc. Ang tingin ko ganito, kahit sino na nasa posisyon namin sa Korte Suprema, hindi dapat maging komportable. Hindi naman to posisyon na pwede ka maging komportable. Lalo na pag nakikita mo yung dami ng problema sa pag-administer ng justice dito sa bansa, hindi komportable yon. And pag kami naging komportable, delikado na. So, yung sabi mong pag-uuga sa hudikatura, ang tingin ko dito, lahat naman dapat ng sangay ng gobyerno, dapat inuuga talaga upang uminog para mag-deliver ng tamang serbisyo sa publiko. So, ang ina-expect ko, More work even, same. On a day-to-day basis, a lot of work for all of us. We have a lot of problems to address. Regardless of who sits, I don't think that any one of us can afford to be comfortable or complacent. The expectations of the public are very high. The cries for justice, the fact that the system has not delivered as it should, these have not been addressed on a systems basis. They must be. And that means that we're in for a lot of work ahead.
Thank you, Chief. Thank you, June. Yung huli magtatanong, June Perfecto.
Good afternoon po ulit. Ma'am, mayroon po akong nabasang US jurisprudence siguro some years back. Ang sabi po I'd rather acquit 10 men who may be guilty rather than convict a man who may be not guilty and make him suffer for the rest of his life. Ma'am, yung pong bang jurisprudence na yun applicable sa Philippine setting?
Naalala ko yung mga prisoners natin, ang tagal-tagal na. Diba? In fact, doon sa in-announce ng latest decision, 18 years, the woman who has been convicted had been staying in jail longer than the actual sentence imposed on her. Maraming ganyan talaga. So, unjust ang system if the detainees are detained too long. The system is unjust if not enough attention has been given to them. So, the adage should be convict when there is evidence, acquit when there is not.
Maraming salamat, Chief. Chief, there are motions asking if we can go beyond the two-question rule, and so I have to address that to you. Would you be amenable to take at least one more quick round if they wish to ask?
But I thought, Ted, you said they were complaining about the length.
Ito po nagtatext
not anymore.
Gusto nila ng pangatlong tanong daw po.
Sige. Okay, sige lang.
Okay, so for those who have questions, we'll take it in the order of questioning. So we'll start with Ed. Third question.
Just a follow-up to the question raised by Virgil kanina. You were talking about the need to address the issues of conflict of interest and, of course, the need to screen properly. And then, and here I quote you here, you said that right now, recent decisions show that we still have a lot of cleansing to do.
Yeah.
I was wondering specifically what decisions you're referring to. Are these decisions of the High Court? And, I mean...
Yes, these are decisions of the High Court dismissing judges, disciplining them. Yes, Ed. Diba, I read the numbers for you, no? We have been dismissing judges and justices, even a justice of the Sandigan Bayan. That means that it is now that we are trying to get more evidence, and now that we are trying to be more proactive, and we have, of course, the cases involving allegations on fixing. This is an indication that there are so many problems right now.
Thank you, Chief. Ina, third question.
What is the assurance to the public that the Maguindanao massacre case, as you've mentioned a while ago, you expect the resolution at the soonest within the year, ma'am? What is the assurance that we will reach that target, considering that Judge Solis Reyes has been shortlisted for the Court of Appeals, at least in one of the vacancies in the Court of Appeals? So if she will be appointed to the CA, then that means that there will be another judge to handle it, and we'll have to study the records, in the entire records of the case, so we might hit a setback or another delay.
There will be definitely delay, because the new judge will have to read the records again. The records have been well preserved, the notes have been well preserved, so I hope that the new judge who will handle the case will immediately expedite the remainder of the job that has to be done. But of course, Ina, this is on the supposition that the undertakings that were made by the prosecution and defense that were relayed to me hold true. So there are factors that are beyond our control here, Ina. Although I projected optimism, it's because those commitments had been made in court.
But you don't think, ma'am, that will be a major factor, ma'am, a new judge to study a very thick case file?
Well, I do not want to add to the level of fear about the case anymore. Let me just say that I gave you a positive projection, and my hope, like yours, is that that will, in fact, be fulfilled.
Thank you, Chief. Donna, third question.
Good afternoon again, ma'am.
Hi, Donna.
Yes. You mentioned earlier that any delay in judicial proceedings is by itself a very grave injustice. I'd like to ask this question about the Mama Sapano case. If the delays are not within your gambit, do you think the Supreme Court has to step in to find solutions, systematic solutions, maybe by putting a timeline or something, by which to address this issue? Because to finally put justice, give justice to where it should be given.
You're referring to Mama Sapano? Maguindanao.
Yes.
Yung Mama Sapano, it's not with us. It's not with us. So just to clarify, not all delays are inexcusable. What I'm talking about is the undue delay that is prevalent right now. So we're trying to do away with prevalent delays, but there are sometimes unavoidable delays. When you cannot rush a proceeding too far that you basically are already perceived to be denying the right to due process. Whether you are rushing it so that you can reach a verdict, or delaying it so as to deny the expeditious closure of the same, anything that is undue delay is anything that is undue is wrong. Okay, so with respect to the Mama Sapano problem, it's not with us. So I will not venture to speak on something that is really purely within the executive department so far.
Thank you, Donna. Thank you, Chief. Tara, third question.
Last year, at the second Beat the Press, you aired concerns about the lack of support, funding support from the executive, and this year, the judiciary has been given funding. So what do you think has changed in the relationship between the executive and judiciary, and to what do you attribute that sort of tipping of the scale?
I think something clicked in the public mind. I think the idea of efficiency in the judicial system gained traction. So, and our services became perceived as something that really must be funded. So the message reached the appropriate audience, and so we are getting the financial support that we need now.
Thank you, Chief. Kaka, Ray, Panaligan.
Magandang hapon po ulit.
Magandang hapon rin po.
Ito po from magsasaka to litigant to construction worker. Sabi po niya, yun daw pong kinatatayuan, hindi naman po ito related sa merits ng case na po. Yun daw pong kinatatayuan ng Torre de Manila ngayon, na in-stop nyo and the case is pending, yun daw po sana ang tatayuan ng Hall of Justice ng Maynila. Tama po ba yun? At kung tama po, bakit po napunta sa DMCI, sa Torre de Manila at hindi Hall of Justice ng Manila? From a construction worker.
Hindi ho tama yung impormasyon nyo. Yung dating plinano nila noon na pagtatayuan ng Hall of Justice para sa siyudad ng Maynila ay yung dating High Alay po. So hindi po, iba pong lote.
Salamat po sa naintindihan na niya. Salamat po.
Thank you, Kaka. And third question, Erin.
Yes, I have a few, but I'll stick to the question of Ina. Yes, it has been reported that Judge Sol is shortlisted for the CA, and she has performed well in the Maguindanao case. Now, is there any, and let's venture that she may get the nod of the President to be appointed to the CA. does the Supreme Court have the power, even after the appointment, to ask her to continue hearing the case, even as a Justice of the Court of Appeals?
Wala na. Hindi na namin siya pwedeng ilagay sa trial ng isang second-level trial court.
Thank you, Chief. Thank you, Erin. Arlene, third question.
Ma'am, third question on reforms. Ma'am, kanina, one of the good things that you mentioned is the full implementation of the accountability of the courts. And I think that's very good. Maraming matutuwa dyan. But the question is, what has been done on the security aspect of judges being subjected to harassment, intimidation by interested parties, or those directly involved in the case? And there are many, I'm relating this to what you mentioned earlier, level of fear of some judges in dispensing the decisions on very controversial cases.
One of the goals of any leadership should be to assure the wellness of the employees, and the foremost of these concerns is security. Some of our judges have personal bodyguards already assigned to them, especially those who are handling the cases of big-time drug lords. You can just imagine that these judges live with their bodyguards 24/7. And of course, Judge Solis, as you all know, have bodyguards 24/7. We have a training program that trains judges on self-defense and using handguns. It's for defensive purposes. It's not a nice piece of news for you to hear, but that is the situation. We're drawing up a security program for them, trying to find out in what way we can enhance their protection. I have been looking at requesting for an increase in the number of personnel that will be assigned to them to include a driver bodyguard. Some of our judges, for example, are assigned in Mindanao, where you have a female judge driving a vehicle for 10 kilometers of lonely road at a stretch. You know, these are very brave women. That particular judge just keeps a handgun in the glove compartment, and she's ready to use that to defend her at the right time. But I'm sure that is inadequate. She's just doing that so that she cannot be accused of not taking care of protecting herself. We are inadequate in protecting our judges. And this system is tied up to the law prevention capability of our government, because we are not supposed to be primarily concerned with lives and safety. Our competence is something else, but we are required to confront that issue on a persistent basis. So I have considered and I have discussed very, very lightly with some of my colleagues the idea of creating a judicial marshals system where some of our employees have the ability to protect the judges and add some muscle to our ability to enforce court processes. But that is a long way off. So right now, when a judge writes us and says that there is a security threat to her or to him, then we assign police bodyguards if we can get them, or if we have security forces still in our team and it's not a very huge force, we assign them to that judge. Unfortunately, we have to tell our judges that they have to take the risk of the assignment. And when the risk is real, sometimes we reassign them to other locations. One from Mindanao will be assigned to Cebu, and then sometimes the litigants themselves can ask for a change in the venue of the hearing. So we move it usually in Manila, where the expectation is that the level of security would be higher. And those are some of the mitigating measures that we have been employing. Admittedly, they are far from adequate.
Thank you, Chief. Thank you, Arlene. The next is Joseph Moro.
Hi, ma'am. I just don't want to put words into your mouth, but correct me if I'm wrong. Siyempre, theoretically talagang may mga MR naman, no? Na period na allotted for every decision. But this particular Enrile case, kahit nakawala na si Senator Enrile, this decision is not yet final?
Yes, because there are pronouncements that have been made by the court. So motions can still be filed.
Thank you, Joseph. Next to ask, Virgil Lopez, third question.
Good afternoon, ma'am. You were quoted in a report last June that you're looking at setting up a committee that would review the SALNs of the members of the judiciary. Meron na po bang committee ngayon, and what is its scope? And does it include releasing the summaries, SALN summaries of the judges in the lower courts as well?
The setting up of such a system is in line with the Code of Public Ethics and Accountability, which says that there should be such a review system in place. And the point is, I want to identify the objectives of the SALN law, which is to first assist the law on illegally acquired wealth, where there is a presumption of illegal acquisition when there is a significant departure on the assets that are actually found and the income of the public employee. So I am trying to look at the objective of that law and how to help make that filing more consistent with the purpose of the law. I am trying to identify the members of that committee. I am exhausting already so many. I'm making use of the services of retired justices even to help me. This is one of, I have not yet created such a committee because I have to identify the people that I still must put in there. But I am determined to put one because I have to really create a committee to review the compliance with SALN filing.
Thank you, Chief. Thank you, Virgil. Joel Quinto for the third question.
Ma'am, after the defense and the prosecution rest their case by year end, when can we expect the verdict on the Maguindanao case?
Well, there should be a 90-day compliance with that. So let's see. Let's see. But as I reiterated to Ina, it's not completely within the judiciary's control, no? Is that to Ina, no? That the Maguindanao, yeah.
Thank you, Chief. Thank you, Joel. Mark for his third question.
Chief Justice, I understand that you are restrained to keep silent again on the issue of the issue between Justice Bersamin and Justice Leonen. But I would just like to ask, did it ever occur to you, did you ever had the urge or to, at least, we know that you belong to the dissent, but did it ever occur to you to go in the middle and try, as the leader of the Supreme Court, did you ever want to try to appease or pacify the two parties, just like parang you're like a nanay of the Supreme Court, to find a venue kahit na outside the deliberations, but it's still internal processes to actually find a venue for reconciliation?
Well, maybe you do not have, maybe there is a misimpression on what the whole thing is all about. Maybe there is a misimpression on the part of some that sharp disagreements are to be avoided at all costs. My view is that sharp disagreements are par for the course in our kind of work, where you have a collegial body deliberating on a controversial topic of strong-minded individuals. And as long as these are individuals, each one being responsible for his individual vote, the likeliness of a sharp response is there. And it is not something to be, on my part, taken aback by. So, I take it as part of the normal load of work that we have.
Thank you, Chief. Thank you, Mark. June Samson, third question. Wave na. Natanong na ni Mark. Okay. Last question, June Perfecto, with the third question.
Madam Chief Justice, do you have a time frame within which your judicial reforms will come to fruition, ma'am?
Actually, the plans are so many, so there are timelines for each one. I had given you just a few of the entire menu of plans that are being undertaken, because I don't think the public will enjoy finding out how we do process re-engineering inside, or the administrative reforms, payroll reforms, financial reforms. Those are not matters of high interest to the public. Each one has a timeline. The one I want to really see come to fruit immediately, and which can really be very tangible to the public, is continuous trial for some pilot courts spreading out in more areas of the country, people feeling the liberating effect of an efficient continuous trial process. Automation, of course, and the public being attuned already with the fast systems that are happening, especially with automated hearings. As you can see, I was able to give a partial rundown of our targets until 2016, because the money has already been committed by our partners until 2017. Some monies are still going to be left by our development partners in 2017, but come April of 2016, I will be submitting a new budget for 2017, which at that time I'm willing to discuss with the public, or I'm willing to let the public know the targets for 2017 for automation. I hope that by 2016 and 2017, the turnaround time for these major projects is so high that you will already see a significant shift in the perception of the public whether efficiencies are really taking place. So mark the end of 2016 and 2017 as important years. And then those are near terms, but after 2017, we plot again. And we are now starting to make a multi-year budgeting program with the assumption that we are not going to get significant support anymore from development partners, because I don't want us to be heavily dependent on development partners. But we have actually two who are very, very committed to helping us. EU until 2022, am I right? 2022, and the USAID until 2017. But they're not going to answer for all. They get to agree to the pilot sites. What I'm concerned most are the automation of sites in the so-called missionary stations. Those where the economics do not seem to turn out the justification for investing in technological expenses for them. But where I think we must really invest to show that civilian government exists and justice is there even in the hinterlands. We cannot just have justice for the cities. We must reach out to the farthest flung areas of our archipelago, even to the south, even in the violence-torn areas in Mindanao.
Thank you, Chief. If you don't mind, I'd like to just run down a few of the questions from social media. Many of them have been answered already in the course of the discussion. The question of at Margot Salcedo has been answered in relation to the Comelec case. The question of at Lenesca Journal has also been answered in relation to the Enrile case. And the question of at Jester in Exile regarding the timeline and plans regarding networking, digitization has also been answered. There are two final questions from social media. Maybe we can end with those two questions. The first question at Stravinsky PH. Why did she, meaning you, Madam Chief Justice, react to Mama Sapano ASAP? It was unusual for a CJ.
I went to the wake of the soldiers as a Filipino citizen. Now, some of the key people who are helping me security-wise are from the uniformed forces. Out of deep respect for their love of country and for the heroic sacrifice they are doing, It was a very small gesture on my part. I didn't think it would be unusual. I think it was only a very human response to a tragedy that in some way affects us all, and me, especially because I have been benefiting from the services also of the PNP.
Thank you, Chief. Our last question, perhaps from social media also, at J. Lawrence. He or she asks you to speculate a little. What could the judiciary do if its budget is equal to 1% or 2% of yearly GAA?
At the moment, I stopped counting until 26 billion. So I cannot account for 4 billion more. So let me just prove that I can spend what has been judiciously, what has been given us, and then I will come back to you and tell you if I asked for too little.
Thank you, Madam Chief Justice. With that, we now bring to a close this year's edition of the Chief Justice Meets the Press. We want to thank the Bailey for hosting us. We also want to thank the members of our panel, Ed Lingao, Ina Reformina, Donna Cueto Ibanez, Tarek Ismundo, Ray Panaligan, Erin Tanyada, Arlene de la Cruz, Joseph Morong, Virgil Lopez, Joel Ginto, Mark Meruenas, June Samson, and June Perfecto for taking part in the third edition of the Chief Justice Meets the Press. On behalf of the Chief Justice, the Honorable Maria Lourdes P.A. Sereno, and Associate Justices of the Supreme Court, we thank you and wish you a good day.
Thank you very much.
We'll have a
Thank you.
photo opportunity in the middle with the Chief Justice and the members of the panel. Thank you very much.
Thank you.